Recording started.
Hi, everyone. We're going to give everybody one more minute to log on. Everyone, good morning. This is Mark Schneider from FOJP Service Corporation. As everyone knows, probably by now, I'm the manager of all the management and liability programs. And welcome to the second annual Directors and Officers Employment Practice Liability webinar, sponsored by FOJP and Crystal & Company. In preparation for this year's June 30th D&O and EPL renewal, we've reached out to most of you and are still in the process of reaching out to many of you to set up client visitations, to talk about, review your current terms and conditions on your current D&O and EPL insurance policies, to make sure you're comfortable with the NAVRIS system, talk to you about any outstanding claims issues your individual agency or individual organization may have. And also, of course, make sure you're comfortable with the NAVRIS system. A quick pitch for NAVRIS. We're really proud of how far it's come along in the last 2 years since I've been here. Chris Balestra has done a great job, and he's sitting here with me today. We sent out a few weeks ago, and we sent you our initial introduction to the D&O EPL renewal. We sent you out an attachment that gave you instructions on how to update the information in NAVRIS. and that attachment is also available in NavRisk itself. But if anyone has any trouble with that, as usual, you can contact myself and or Chris Balestra, and we'll get that to you right away. Without further ado, I'm going to get started. Please go to slide 1. So I'm going to speak just for the first 2 slides about risk management in general. Risk management is, when we're talking about risk management, we're referring to the management of accidental loss, and that's simply a condition that could cause your organization a financial loss. We often, for our kind of risk management, that's a term that's thrown around a lot. Our kind of risk management we refer to as hazard risk, and hazard risk is a peril or a hazard. How insurable a peril or hazard is depends on the risk manager's ability to effectively manage that exposure. So starting out here a little technical, but what we want to do is help you to understand that we're here more than just simply to help you procure insurance appropriate for your organization. We also want to help you how you should see it conceptually from the 36,000-foot viewpoint, and get an understanding of the kind of things what you should be thinking about and how we can help you with that. In the case of D&O and EPL insurance, we are often considering what can be referred to as human perils, and that's behavior that generally can be managed, and sometimes cannot be managed. Human behavior and the human condition is a funny thing. I know we all work at best to bring in the appropriate people into our organizations, and sometimes we make mistakes, or sometimes things change with the organization or those people, and that can lead to a risk. A loss, and those losses can cost you money. So obviously the point of this is that we're here to help you strategize and to prioritize for uncertainty. So moving down the page onto solutions, when we're talking about risk transfer, a couple thoughts here to talk about. The first point about third-party contracts, that is when you have a contractual relationship with some outside party, and you can shift the exposure to that outside party as appropriate. Sometimes, unfortunately, if you're not paying attention to a contractual relationship, you can also land up unintentionally taking on more exposure to your organization. That's something that we can help you out here. We are not lawyers per se for the client base, but we do help with insurance and defense indemnification language that's applicable to this kind of risk. When we're referring to risk mitigation, we're talking about the way to reduce the chance of a loss. We want to make sure that you have a process in place that minimizes the potential for a loss. A written process is what we know that will help you help your organization be aware of everything outstanding that your particular operations go into. And obviously, being aware of something and writing something down is always a great way to help you understand something and face it head on and consider it more carefully. When we're referring to risk avoidance, we're talking about avoiding some operations that may not naturally be in your organization's repertoire. For example, we are aware of some corporate clients who have sometimes started some child care operations, and it turned out to be too great a requirement of too many resources for that corporation to correctly handle that kind of exposure of watching people's children while the employees are working. So they get out of that business politely and gently. A lot of time these operations are taken on with well-meaning and good intentions, but it just can be sometimes too much for the organization to handle. But at the same time, many of you, the clients on this call, are in the business of child care and are aware of those of the exposures and all the risks involved with that, and have taken the appropriate precautions. We know you have, and have the appropriate processes in place. Why don't we flip to the next slide? This is a nice chart here that we provide here to help you to give you a visual conception of when we should transfer risk. Starting at the top box, catastrophic potential obviously refers to the first thing to worry about is whether there's a real large potential for a financial loss. These are the kinds of exposures that we usually recommend you purchasing some type of insurance product. The second box going down to your right is your susceptibility to a loss. And that's an area in your practice that could give rise to a potential loss as well. For example, as I just mentioned, many of the UJA-sponsored agencies on this call have child health care operations. Clearly, that requires certain risk management, certain mitigation of exposure where possible, and of course, the appropriate insurance in place. Moving down to the bottom box on claims trends, a perfect example of a claim trend is EPL insurance. 25 years ago, there were no EPL insurance claims, and now obviously the claim count on that exposure has grown dramatically. So when you see an exposure that the industry or your organization or the market that you work in has a lot of claims, that's a key sign that you should be getting an insurance product for that. Finally, of course, the last box on the left, predictability, the obvious things, a fire, flood, windstorm. Underwriters know when, from an actuarial basis when those are going to happen. Our commercial insurance products also focus on the unpredictability, in this case of human nature, and that's what these policies speak to. So with that, we're going to switch to the next slide and allow me to introduce Michael Santaki. Many of you have met Michael already. Michael is an old friend of FOJP and many of the UJ agencies and the other hospitals and long-term care clients. Michael's been with Crystal & Company about 7 years. I've worked with Michael, frankly, on and off on these product lines for close to 15 years. He's considered one of the top-notch experts in this field, and we're really lucky to have him on board here. And with no further ado, Michael, why don't you go on and speak about Directors and Officers Insurance directly.
Mark, thank you very much. Good morning, everyone, and thank you for having me. At this webinar, and I hope to be able to do these as needed and all the time for you guys, I want to focus a little bit on the D&O and employment practice segment, because I think these areas are having some news, and it's important to share that with you. What I'd like to sort of focus on especially is, in this short time, just sort of to give you some of the statistical issues that come up, and maybe some tips and some suggestions to avoid risk, to avoid claims, and to improve your risk management. First off, here's a piece of bad news. When I can get a slide out of reading my newspaper, that's not good. April 10th, I knew that we were having this webinar, and I was starting to think of slides, and I was reading the New York Times, and this quote comes up. Generally speaking, I think we've all been a little immune from D&O type claims, but I think we've all sort of noticed some things going on in the community that may implicate D&O claims, and I want to spend some time on this. But this was an article regarding Cooper Union, and I'm going to go into this a little further, but the Attorney General has said that the laissez-faire approach to nonprofit governance is over. So that's probably not good news for us to hear, even if we have perfect D&O boards and everything. So first, a couple of trends and statistics. Next slide. The D&O marketplace for nonprofits is a $380 billion market. There was a time a long time ago when brokers had these documents for distribution called Why a Not-for-Profit Should Buy D&O Insurance. And we don't even have those anymore. So I think we've certainly moved to a point where nonprofits may have considered D&O to now this is something that all of them should have. And I always like to give you guys some data, because I think there's not enough of that. And people want to know, well, how much does it cost and what are the exact figures? So the average cost of a D&O claim, and this is just the average and it includes defense costs, is $698,000. I think it's a fairly significant number for a claim, and one that all of you would be pleased to know is generally covered by these insurance policies. So when Mark talks about the risk transfer, the good news is that D&O risks, outside of probably what I would call real intentional acts, are generally something that you can transfer onto an insurance policy. And by the way, claim reporting has tripled in the last 5 years for periods that they report. So now, the sources of claims, because people used to always say, I don't have shareholders, where am I getting lawsuits? First, government regulators. I think there's been a real step up on the government side to, frankly, probably raise money. I mean, there's always a cynical side to these, why are claims up? Why are claims up? The government has public policy reasons, but they're probably interested in raising revenue, not unlike the traffic tickets we get in our town sometimes. But anyway, violations of law could now stretch from privacy to the IRS, to the EEOC. All these government regulators could come in and impose penalties, and a lot of D&O policies have coverage for these fines and penalties that they didn't used to, say, 5-10 years ago. The other source, donors and beneficiaries are suing, and again, the cynic in me says, they're not necessarily suing because they don't like your organization. A lot of them are suing because that's money that they feel they wanted, and when their parents are giving money to a nonprofit, if there's a way for them to try and claw back some of that money, they'll bring a claim. One of the big claims here was Princeton University that got sued for mishandling a huge donation, and it was a very, very large claim. We're seeing some third-party type claims. Suppliers, other nonprofits may bring a claim if they, let's say, hire a few people from another not-for-profit and someone sues them for interfering with contract. We've seen some of these claims, and again, these type of claims, while maybe not directly to the directors and officers, are covered by the directors and officers liability policy with the entity coverage that you have in that policy. There are creditor claims, and there's one big case that we're going to talk about in a few minutes where the creditors sued the board of directors for breach of duty, and they won. So all these areas are sources of claims that go beyond the sort of traditional shareholder approach. Just to sort of quickly touch on some key coverage issues, and by all means, if you guys have questions, we can do them later. We can have a session to discuss something in depth. But I think the first and foremost, most important issue on these D&O policies is, do you have a duty to defend policy or a non-duty to defend policy? A duty to defend policy means that the carrier has to defend the claim. You essentially tender the claim to them for defense. A non-duty means that you hold the claim, you get the law firm subject to their consent, and they will reimburse you. A duty to defend policy has a huge advantage in that if there are covered and non-covered counts to the complaint, the duty to defend carrier has to defend the entire claim, whereas in a non-duty, they can allocate covered versus non-covered counts. The advantage of a non-duty policy is there's a sense of greater control. So it's really a sense of control up against, potentially higher covered dollars. My general view is that for larger, more public space organizations, some of them may prefer control. But if it were me, I would always take greater coverage and seek the duty to defend approach. The other thing is these policies are claims-made policies. A claim has to be made during the policy period and reported during that period and the reporting period. In certain cases, and I don't think any of you specifically have this, certain prior acts may not be subject to coverage. The definitions on a policy, of course, are really important. It's important to have broad definitions of insureds. I mean, I can't tell you that on occasion I've seen nonprofits not having volunteers covered. That is a huge mistake. We do not have that on any of our policies. The definition of claim should be broad, should include arbitration, mediation, and a few other things. I've seen some policies, again, none of yours, that actually don't have criminal charges covered. That has to be on these policies. In terms of policy extensions, there's a few items such as outside directorship, and this is an important point. You can get coverage if you direct one of your directors to sit on another board. The important point is if you do that, to have a written request in the file that asks that director to sit on that board. That's a precondition to coverage. In an outside directorship scenario, there would be what's called double excess coverage. First, there would be that organization's indemnity, then that organization's policy, and then if those are not available or exhausted, then the policy, your policy would be available for that director on the outside board. There's IRS tax coverage on these policies for certain fines and penalties. Nonprofit D&O policies have personal injury coverage, wrongful detention, libel, slander. That's not on private company forms. There's also some plagiarism coverage, so if you guys publish and you don't have a dedicated media cover, there's some coverage on this policy. Now, just to talk about something in red, there's ODL and IDL. ODL is the outside directorship that we touched on. IDL is something called independent directorship liability. In discussions with Mark this year, we want to offer that product to you. I won't say that it is the most popular product around, and it's really suitable for directors who sit on multiple boards, and it gives them a sense of personal coverage that attaches on an excess basis to their policies. But I think it's a good idea in risk management to offer that to your board members, and Mark will be in touch with you to do that.
Right, just to add to what Michael said, independent director's liability is a product that we would, recommend or at least make available for you to discuss with your individual board members, and that would be a purchase made by the individual board member if they have any concerns regarding any of the boards they're sitting on, and we can talk to you in greater detail about that when we do our visits.
Yes, this policy is meant to benefit the individual board members and not necessarily the organization itself. Severability is very important to make sure that you have the best severability on a policy. What severability implies is that if there is a bad actor, how much of that will fall onto others. So a good D&O policy will say that one bad actor cannot impute his knowledge or fraudulent activity onto anyone else. And then the issue is how it applies to the entity for denial of coverage. And generally, only someone in a top 3 position, which would be a CEO, a CFO, or a COO, could their bad acts be imputed onto the entity for the purposes of denying coverage. The last quick point on sort of these coverage issues is the hammer clause. And I want to just bring this to your attention because a lot of people just don't know about it. But most policies have this clause that basically says if there's a settlement opportunity and it's favored by the plaintiff and the insurance company, but you want to proceed either to summary judgment or whatever, at the point of the rejected settlement, you would lose all ongoing coverage. The original D&O policies had that wording. We have now negotiated these things where the penalty is pretty much down to only 20%, meaning that if you reject the settlement, at that point going forward, you would have 80% of your coverage. I will say the reason it's there, because some people may wonder, why is this clause there? In the EPL context especially, we have seen cases where somebody is incentivized either by bonus or some other reason to deny the charges made against him, even if they may have occurred, and he or she may be incentivized to have the case proceed when it's really not in the best interest of the organization to proceed with the case. So in that area, I think that the carriers want to sort of have this hammer clause in there so you don't have the full capability of simply saying, I don't want to settle, I want to roll the dice. You have some sort of skin in the game in that case.
Next slide, Samantha.
Next, I just wanted to talk about some of the cases that have come across us recently as sort of, giving you some guidance and some tips for things that went on in other organizations that caused, big losses. The Leamington Home for the Ages case was a nonprofit board, and the basic holding of the court was that they're held to the same duty of care as their peers in a for-profit organization. And I think, most of us probably assumed that to be the case. But this setting is kind of interesting. This home was a long-standing old age home founded in 1883. And they went south financially, and the claim was brought by their unsecured creditors. And what was unveiled was the fact that they didn't keep corporate minutes. They had attendance at board meetings that went under 50%. A quorum was not imposed. There were no-shows at board meetings, and the entire board members had relationships with an affiliate entity that they were essentially favoring some contracts to. When this got exposed, it led to $2.5 million to the board, an additional $1 million to one individual board member alone, and $750,000 of punitive damages. Now, I know this sounds like a bad case. I mean, they didn't have minutes, they didn't go to meetings, but, these are things that I suspect happen more often than not. And the issue is once the claim comes out, these procedural matters really come to cause problems for the board of directors. The next slide is interesting, and again, this comes from the New York Times, and this is where the Attorney General quote was from. There's no trouble at Cooper Union, but yet they have an investigation. What happened at Cooper Union, and some of you may have read the article, they decided to charge tuition. Cooper Union used to be one of the few, if not only, organizations, educational organizations that did not charge tuition. The Attorney General decided to investigate this. There's no imminent danger of financial ruin or financial issues, but the Attorney General wants to prevent mismanagement before it starts. Now, what have they found? They found that the board approved a loan for 30 years with a higher rate than they should have maybe, and there was a very costly prepayment penalty. Cooper Union also owns the Chrysler building, so they're probably in excellent financial shape, but their remaining investments were made in hedge funds and high-fee private equity investments, and the returns haven't been great. And all this is sort of creating this groundswell of an investigation, and at this point maybe nothing more, but there are costs associated with this investigation. And again, my point here is that nothing happened. There's no allegation of fraud. There's not even a financial ruin situation, but yet this board is subject to an investigation. This slide also from the New York Times, but it's not as topical. I got this from the obituary section. But Peter Diamandopoulos just passed away, and he was the president of Adelphi, and it was one of the larger university claims. This claim was over $10 million. And, you know, I sort of was reading the obituary and I wanted to get a sense of sort of how they got to this $10 million loss, and if there's any lesson learned or tips to be shared. Peter Diamandopoulos came from John Silber, who was sort of a dynamic educator. I think he actually ran for governor in Massachusetts. But he transformed Boston University, and really, I mean, from what I understand, he raised endowments from like $18 million to $400 million. He got paid $6 million at retirement. Nobody brought a claim because everyone said it was money well spent. Peter Diamandopoulos was his protege, and when Adelphi hired him, there was a sense of a huge win at this sort of local Long Island school to get, you know, one of John Silber's guys on board. You know, when Peter Diamandopoulos was described, and this is important, I sort of pulled this out of the obituary, he was described as a visionary, a guy with a clear sense of how to raise money for schools. He was also called a despot and divisive. He had very high salaries. He had an apartment on Park Avenue, and that's not really that near Garden City, but he got an apartment in Park Avenue, and there was a high sense that he would change the university and bring it up to speed. In that article, the board was referred to as compliant and having never verified results. All these things sort of led to this recipe for disaster because he didn't succeed in transforming the university, as I think some people thought he would. And the claim actually got started when radio station funds were off, and some of the students involved with the radio club had brought the suit. And then it sort of steamrolled into all the money spent at the board level and all these other problems. Again, hopefully some lesson learned out of these things, but you know, always be careful when you get the guy you think is great and sort of have the sense that, you know what, I got the right guy at the helm, I don't have to watch as closely. Anyway, we're going to move on to the employment practices side now. Do you want to pause for questions for D&O now, or keep it going? Okay.
Keep it going. We'll do that at the end.
We'll do some employment practices, and then we'll go for questions. So again, just some of the trends. And employment practices, I think, has a lot of moving parts. 88,000 charges with the EEOC in 2014. What's interesting and where there's a lot more case activity is wage hour type cases. That's seeing a 26% increase. The most common charge we get is retaliation, and retaliation is always problematic because there's an issue of shifting of burdens of proof, and in retaliation that burden may shift under certain scenarios onto the insured. Interestingly, the most likely to find a cause of action have been the sexual harassment cases, the Equal Pay Act cases, and the GINA, which is the new law on genetic information and using any genetic information to discriminate. The least likely, more recently, is race-based charges. Some more statistics. The median jury award for an EPL claim is $325,000. Over half of these claims will settle for over $250,000. And the median award for a settlement is $100,000. Hopefully these numbers are kind of useful, just because I always like to have the amounts in my head when I deal with the nitty-gritty of the cases. I want to know what their value is. On average, defense costs can be about $150 to $200, and that's probably taking a case into a deeper settlement or trial. Interestingly, 40% of all EPL claims are brought with entities with under 100 employees. And I think that should resonate here. We have a lot of smaller organizations, and the sense that they're less susceptible is not necessarily true. Employment claims represent a full 30% of all civil litigation in the United States. You know, when I was reading this morning in the paper, there's a lawsuit against Al Jazeera for discrimination. You know, and when I read it, part of me said, you know, they must discriminate against this guy, and they were making some anti-Israel comments. And then the other half of me, knowing the EPL setting, is there's no knowledge that these accusations are true. But what's interesting out of this case is the sense that it's very easy to get in the newspaper. And I've heard from someone that the New York Post especially really sort of trolls the court filings because they like these sort of exclusive articles. But this is a perfect example of something that either Al Jazeera is guilty of or they're not, and yet they're in the New York Post. And I think there's some people, again, myself included, that may have read that with at least part of their brain saying, you know, aha, we got them, they discriminated. Anyway, moving on to some of the claim types, and most of you probably know some of these. The wrongful termination is very common, and frankly, those are the most likely where you just don't know whether they were terminated for a good cause or not. But, you know, if someone gets terminated, there's not much disincentive for them maybe to consider a settlement or a severance and bring that charge and get a letter from a lawyer. Harassment cases still there, but maybe less on the traditional scale of things, but there are variations of it that continue. Discrimination takes on, you know, all new sorts of sides coming from federal law, state law, and city law, which differs. The GINA cases are an example. And again, in one case I read there was a woman taking a lot of time off from work to get tests done. She had some genetic issues relating to breast cancer. In their mind, they may have terminated her for not going to work, and maybe they didn't expect to get a GINA claim, but that's what they got. And again, as I mentioned, those claims have a higher likelihood of success. So filing a GINA claim may be a better move than filing a wrongful termination claim. Workplace torts, we continue to see a lot of claims in negligent evaluation, negligent hiring, and I'm going to get to something in a moment on that one. And then the area where we see really a lot of activity is wage and hour. And I'll sort of pause here on this one because some of you may be asking, but there's no coverage for this. And again, as Mark referenced, you know, our jobs are not simply to work in the world of coverage, but they're to work in the world of risk. And wage and hour is certainly something that's coming up. You know, and just to briefly explain it to you guys is, you know, wage and hour comes from the sense of having not been able to classify employees properly. The two types of claims we see most relate to, and this doesn't apply as much to your situations, companies that make employees put on certain uniforms and make them clock in before they put on the uniform. There's been cases like Tyson Chicken where they've had to pay $38 million because that 20-minute interval to put on a chicken-type outfit every day had to have been done after they clocked in. The other type of claims, and I'll use a Best Buy setting where you have someone who's an hourly employee and you decide to promote him to assistant store manager. He's got the same hours, but now he's not getting overtime. The question is, was that promotion a valid promotion to a different job with responsibilities, or was that a way of just shirking his overtime? There's a lot of these claims, and the solution in the marketplace is limited. There are products in Bermuda that have $1 million deductibles, which would probably not make them applicable for you. There is a product in London that has a $350,000 deductible. We're looking into that a little more, but I think that that's still a high number. The other side is to consider another vehicle for transferring this risk or mitigating this risk, and that's to really have a law firm do a quick audit if possible to see how compliant you are to wage and hour law.
Just to add to what Michael just said, just to emphasize, we will obviously different clients on this call have different size of resources. So we're going to, when we speak with you each individually this year, when we have our client meetings and/or when we're proposing options, we will let you know what the best available options are for your individual organization's case in regard to wage and hour coverage, whether it's full coverage or defense only. But we are looking into that, and we'll speak to each of that with each of you, sometime in May or June.
And just going into a couple of key coverage issues. Again, we discussed the wage and hour. Third-party liability is something that comes up, and that is something that's on this EPL policy, but there is coverage for third parties who will claim discrimination or harassment. Those third parties could be an applicant for employment, they could be a vendor, they could really be anybody that visits your premises that is not an employee that still can bring a claim. One thing I always mention every time I bring this up is remember that an EEOC charge is a claim and your notice obligations under a policy are triggered. So at the EEOC charge, you must notify us that you have a claim. The other side also on these policies, there's quite a lot of risk management services. There's a hotline with a law firm. We can generally get you more time if needed. There's also some online tools, and I think Mark, myself, Allison can help you with that. But if you have any issues, you want to do a new handbook, these are things that the policy itself can help you with. Just sort of to go over a couple of the high-profile claims in the employment setting. You know, I think a lot of people were following that Ellen Powell claim in Silicon Valley. It was a gender discrimination claim. You know, people have asked me for my comments on it, and I don't, you know, there's no groundbreaking law here. I think at the end of the day, there were two things that I saw at least. So item one was, yeah, I mean, there was some glass ceiling issues. I mean, you know, and if you have senior management folks going to a steakhouse, playing golf, there is a certain argument that those are events that maybe some of the female employees aren't going to, and that there is a sense that they're not giving a fair opportunity to participate at senior management meetings and things like that. On the other hand, with this case, I don't think we had a great plaintiff. I think that there were some issues with her management skills at her level, and I think that in this case it just sort of precluded an award in this case. But it was certainly a case that put the employment practices issue on the front pages, and it was something that people were discussing and following. You know, another case fairly recently, it's thing you have to be aware of is, you know, transgender discrimination is prohibited, and cases where, you know, in this case, I believe someone applied for a job and a while later got the job and showed up in a different form. That's, you know, you can't discriminate against that. A Ford case recently, basically an employee wanted to work from home. The case went to the issue of whether, what's the workplace, and the court said in this evolving era, the workplace can be anywhere. And again, it doesn't necessarily mean that person could work from home and she won the case, but at least the court sort of determined that with technology, the workplace is not necessarily the traditional office space that people go to. And lastly, one case locally that came up was a request for an indefinite leave of absence is not per se unreasonable. I think a lot of the cases have been shifting towards favoring employees and certain things that employees are seeking. Management has to be aware that they may or may not be, you know, per se problematic. You know, the next stage in employment practice law, you know, first, New York, it's important to keep an eye on New York laws. Recently, there's a law about mandatory paid sick days, but people who do an HR function should be aware of what's going on locally in New York. In other areas, these ban the box discussions. New Jersey has prohibited it. New York, not yet, but they will. The issue is whether you can ask someone about their criminal record at the inception stages of the application process. So not to say down the road it can't come up, but that at that early first application stage, is it a good idea for public policy to not have that question so you can at least have qualified people who may have had a prior record go through that process. Again, leaves of absence, we have seen claims with our clients on this. You know, military leaves, there's a blood donation leave, a certain amount of time allocated to giving blood, jury duty, there's a certain time for voting, on voting. Crime victims have certain leave of absence rights. You know, moving on, the next one always sort of seems to get a chuckle at these seminars when it comes up, but I think it's moving to the forefront in the sense that, you know, everyone would say that if you saw an employee smoking marijuana right outside the office, they could be terminated. But what happens in states like Colorado, and what happens if that employee has a medical letter advising him that he's permitted to smoke and he has a disability? This isn't something that's really hitting New York yet, but I think people should keep an eye on, marijuana and the sense that this product, I guess, is moving away from the traditional view of it being prohibited and someone could be instantly terminated for using it. Again, New York is not at the forefront of this, but certainly Colorado is, and Washington State is, and I think Washington, D.C. is coming. Lastly here is just the social media, and that comes up a lot. And that issue is, what discipline can you impose on employees? When is, in the sense of using social media at work, and also using social media on the weekends, but maybe about work. There have been cases about co-employees sending communications to each other about the workforce on their own Facebook pages. Definitions of workplace are not that easy anymore, and definitions of protected speech fall into this. And I think we're going to see a fair amount of case law on this. My recommendation is just to at least sort of draft a policy on this so you have clear rules of engagement. But we're definitely seeing a distinction now in what's the workforce and what speech is protected by employees talking about work after hours, online, et cetera. So, just a couple of best practices for employment practices. And again, I think that having these practices really helps. To the extent you can have a dedicated HR department, you can provide regular training, that you can have clear reporting chain. I mean, this is important. This has come up on a case that we had that was probably of very minimal exposure, that basically had settlement money awarded mainly because they didn't have a chain of reporting. But there has to be a clear chain that employees know about as to where they take their complaints. There's got to be controls, and information has to be disseminated. We recently underwent a privacy exercise with clearly mandated rules about what we do with documents, client information. It's important to inform employees. When there is an issue, hire outside counsel, get the right law firms involved. Obviously establish a stable employment base, but I have had a client that had probably too many reductions in force, and there was a sense maybe that they hired too aggressively when they thought they were doing well and not taking proper stock of how these reductions in force could result in a claim. And lastly, there should be guidelines. They should be properly posted, and again, this is something that a hotline can help you with. But making sure you have best practices can have a real monetary difference in a claim, especially in this area where we see so many claims where it's just unclear and it's whose liability it is, whose fault it is. Plenty of people are aggrieved at the workplace and they bring valid claims and they deserve to get paid. And plenty of people also bring claims that aren't valid. And in that case, probably society as a whole loses, but we all have to pay. Anyway, I think I'm going to open the door for questions.
On that note, does anyone have any questions from either the earlier risk management session or Michael's discussions on directors and officers or employment practice liability? We're happy to answer them. Samantha, how do they check in as a group? They write in the, please type in onto the chat section. Samantha is now making the chat section open to everyone to type in their questions, and we'll try to answer them. We'll wait a minute to see if anybody types in. While we're waiting, I just want to say that, of course, thank you for joining in with us today. We started out with at a kind of maybe a little bit high at a 36,000-foot view of the academic or technical background of what risk management is, and what we really want to do is give you guys something to think about in your organizations as you're considering different operations that your individual organizations run, and to make sure that you're thinking of all the potential types of hazard losses that could happen that could could financially affect you guys. That's also what the point is of us coming out to each individual client and having these discussions close to renewal to make sure we're not missing something, frankly. So it doesn't look like we have any questions coming in on chat. We'll wait another minute. Oh, we do have a question. Can you read that, Samantha? I just can't see.
How much D&O EPL coverage crossover to cyber-related issues such as protection of information?
The question is how much D&O EPL coverage crosses over and eliminate. I believe the question is asking to eliminate the need for cyber insurance. I would say very, very, very little. You know, cyber insurance. First of all, you know, everyone is very aware of cyber insurance, the need for security and privacy of everyone's data. The insurance companies are very aware of this exposure. I've talked to many of you many times on the need to get this product in place for your organization. The problem really being, and Michael could speak to it more, is that the insurance companies are very aware, so they are specifically wanting to make sure they are specifically excluding it from your D&O policy, your EPL policy, your fiduciary policy, your crime policy, your property policy, things like that. So any less? Michael, do you have anything to add on that?
Yes, I mean, I'll say that, you know, the insurance industry is very keen on when they have a new product out to make sure that they get you to buy it by not accidentally giving you that coverage elsewhere. So there's not a lot of overlap in the coverages. They're very segregated. However, there's certainly some overlap in a claim coming in. So you can have an employee filing a claim for some employment matter and then claiming that the employer didn't handle, you know, private information properly. By the way, and that goes back to the duty to defend. You can have a wrongful termination claim, a constructive termination claim, and then someone adding that the records weren't properly kept. That's the advantage of duty to defend. Some of that may get covered on a duty to defend policy, at least the defense would. But again, for the most part, they're very separate in terms of coverage, and you will not get any cyber coverage on an employment practice or D&O policy. And by the way, just to go to the D&O real quick, it is slightly possible that you and I, we have seen this where a board doesn't buy a cyber policy, and subsequent to that, maybe they get sued saying that the board did not address cyber issues, did not buy cyber insurance. That's something that probably would get picked up on a D&O policy, provided, and very important to make sure that you don't have a failure to maintain insurance exclusion, which to my knowledge we don't have. But some policyholders that have that would be a way for the D&O carrier to deny coverage for the cyber claim.
Thank you, Michael. I'll wait 30 more seconds, but it looks like we have nothing more. And I just want to thank everyone for attending. We will attach a copy of this webinar in the D&O renewal inbox in NavRisk. And of course, if you ever need help finding that, certainly give myself or Chris Balestra a phone call. Michael, thank you so much for helping us out today. We appreciate everybody's participation. We kept it to 45 minutes. We're very proud of that, among other things. And we look forward to meeting with all of you soon. Thank you, everyone. Have a great day.